Hello friends, welcome to UPSC Logics, and in this video we shall have a look at the amendment of the Constitution. We shall also have a look at Article 368 and the passage of Constitutional Amendment Bill. So this video is important from the UPSC, IAS, PCS point of view, and before we start this video, if you haven't subscribed to this channel, do subscribe if you like this video, and this video has been done in English. So without wasting any time, let's begin. Let us have a look at the introduction first, and the Indian Constitution is described as both flexible and rigid. Flexible means that certain parts of the Constitution can be changed or amended, and rigid means that there are certain parts of the Constitution that cannot be changed. The parts which can be changed are dealt in Article 368, Part 20, and it deals with the amendment of the Constitution and the procedures that are described in the Constitution for amendment of any part of the Constitution. Article 368 therefore describes that the Parliament has the power to change, add, subtract any part of the Constitution. However, it cannot amend certain parts of the Constitution which are described as the basic structure of the Constitution, and this was for the first time described in the Keshwanandan Bharti case 1973. So I would suggest that you go and watch the basic structure of the Constitution video, so you'll have a better understanding of what these cases were. And till date there have been 101 constitutional amendment acts. The first one was in 1951 and the 101st is the GST. Let us have a look at the procedure of amendment of the Constitution, and for this a constitutional amendment bill can be introduced in either of the houses of the parliament, which means it can be introduced in the Lok Sabha or the Rajya Sabha, and however it cannot be introduced in the state legislatures. Number two, it can be introduced by either a minister or a private member and does not require the approval of the president. Number three, the bill must be passed in each of the houses by a special majority, and this is introduced at the third reading stage. Number four is the houses must pass the bill separately, which means that each of the house need to pass the bill separately. And in case there is a disagreement, there is no provision for a joint sitting of the houses, so a deadlock means the bill ends there. Then number five is that in case this particular bill is amending a federal provision, then it needs a ratification of at least half of the states, which ratify it by a simple majority of the members present and voting. And number six is once the bill is passed by both of the houses of the parliament, and in case it is changing a federal provision of the constitution and is ratified by the state legislatures in this particular case, the bill is presented to the president for his approval, and the president has to give his approval. In the case of a constitutional amendment bill, he cannot hold it or return it as in case of other bills, and once the president gives his assent, the bill becomes an act. So I hope this particular procedure of amendment of the bill is clear. So let us have a look at the types of amendments that are provided in the Constitution of India. Number one is by simple majority of the parliament, and this particular amendment is not deemed as an amendment by the purpose of Article 368. Number two, as we have seen before, the passage of the constitutional amendment bill, and this is done by the special majority of the parliament. Number three is changes in the federal provision of the constitution, and this is done by special majority and ratification of legislatures of at least half of the states present and voting by a simple majority. So let us have a look at what all things can be changed by the simple majority of the parliament. And these particular amendments have been kept outside the scope of Article 368. So there are around 18 points which can be changed by the simple majority. Number one is admission or establishment of new states. Then number two is formation of new states, altering existing boundaries, alteration of areas, names of existing states, and this is ruled by article number 3. Then number 3 point is abolition or creation of legislative councils in states. So Andhra Pradesh, Bihar, Jammu and Kashmir, Karnataka, Maharashtra, Telangana and Uttar Pradesh have got legislative councils. and this can be remembered by the simple term called Kumjat. So this covers all the 7 states which have got a legislative council. Then number 4, it's the second schedule and whatever is covered under the second schedule, which is emoluments, allowances, privileges, and so on and so forth of the president, governor, speaker, judges, etc. Then number 5 is the quorum of the parliament. Number 6 is the salaries and allowances of the MPs. Number 7 is rules and procedures of the parliament. Number 8 is the privileges of the parliament, its members and its committees. Number 9 is the use of English language in the parliament. Number 10 is number of judges in the Supreme Court. Number 11 is conferment of more jurisdiction to the Supreme Court. Number 12 is use of official language. Number 13 is citizenship, acquisition and termination of the citizenship. Then number 14 is election to parliaments and state legislatures. Number 15 is delimitation of the constituencies. Number 16 is the union territories. Number 17 is things which come under the 5th schedule, which is administration of scheduled areas and scheduled tribes. Number 18 is the 6th schedule, which is administration of the tribal areas. Let us have a look at number 2 type of amendment, which is by special majority of the parliament. And most of the provisions of the constitution fall under this particular category and need a special majority of the parliament. So let us understand what a special majority means in simple terms. Suppose there are 600 members in a particular house, then 50% of the members should be present at that point of time when the voting is being done, which means 300 members should be available, and out of this 2/3 of the members should agree that the bill should be passed, which means that it has to be passed by at least 200 members, and this is called a special majority. And the special majority is introduced at the third reading stage of the bill. So the provisions which can be amended by a special majority are fundamental rights, then directive principles of state policy, and all other provisions that are not covered by the first, which are the 18 points, and the third categories, which are basically the federal provisions of the constitution, which need a ratification of this half of state legislatures. Let us have a look at number 3 type of amendment, which is by special majority and ratification of the states. So this particular kind of amendment falls under Article 368 only and is used when a certain kind of a federal structure of the polity is being amended. And for this, half of the state legislatures need to give their consent, and this is done by the simple majority of the state legislatures. There is no time limit given to the states to give their consent, and which can actually elongate the process of amending the constitution for a very long time. So what are the features which can be amended by the simple majority and consent of the states? Number 1 is the election of the president and its manner. Number 2, the extent of the executive power of the union and the states. Number 3, things dealing with Supreme Court and High Courts. Number 4, distribution of legislative power between the union and the states. Number 5, any of the list in the 7th schedule. So the 7th schedule falls under the federal structure. Number 6, representation of the states in the parliament. Number 7, power of the parliament to amend the constitution and its procedure, Article 368 itself. And again, I would suggest please watch the video on the basic structure of the constitution so that you'll understand what all cases have been there in regards to this particular procedure or the power of the parliament to amend the constitution and its procedure, Article 368 itself. Let us have a look at the criticism of the amendment procedure. Number 1 is that there has been no provision for any special body like we have the Constitutional Convention in the United States of America or any Constitution Assembly for amending the Constitution. Number 2, the power of to amend the Constitution lies with the Parliament, and in some cases it lies with the state legislature, so the Parliament can change the constitution according to its whims and fancies. Number 3 is that major part of the constitution can be amended by the parliament either by a simple majority or a special majority. Number 4 is the constitution does not prescribe the time frame in which the state legislatures have to ratify or reject the amendment, which means the particular constitutional amendment bill that is dealing with the federal structure can be elongated forever. Then there is no provision of holding a joint session of both the houses in case there is a deadlock or a disagreement in case of a constitutional amendment bill. And the process of amendment is similar to that of a legislative process. And number 8, the provisions are too sketchy and they leave a wide scope for taking the matters to the judiciary. So friends, this was some information about the amendment of the Constitution of India, Article 368. So I hope this particular video has clarified any doubts that you had in your mind. If you're watching it for the first time, do like and subscribe to this channel. If you're a regular subscriber, don't forget to press the bell icon. And thank you so much for watching, and Jai Hind.